following a definition overrule that decision is the entire ruling. First, thus signifies whole from Merriam-Webster's online in 2006, uses the function before an absolute adjective, and two is overrule means removing an entire legal precedent. As People's Law Dictionary in 2006 to decide that a prior decision on legal issue was not correct and therefore no longer valid precedent on legal question. And three, the holding of a court is response to the case. That's Acker in 2006. The holding of the case is stated in the complete response to the issue as defined. The holding is what the court decided in the case that corresponds to the general ruling extracted from the case decision. The rule becomes the precedent. And B, violation the only overrule subsets the decision. And C, standards one ground along the after overrule subset decision means the applicant pick out a court opinion finds some general language or the technicalities wouldn't be allowed to use based on a lack of specific ground. To limit their interpretation allows for specific change in decision made on minute details, make them defend the entire decision to disallow means impossible to manage changes that would completely underlimit the topic, the excuse topic in their direction, and devoted for ground fairness and education. Next off is the counterplay text. The United States Supreme Court should affirm a federal civil rights remedy for domestic violence by overruling United States v. Morrison, holding that the civil rights remedy of the Violence Against Women Act is constitutional under the 14th Amendment. And observation 1, the counterplay competes through net benefits. Observation 2, solvency. 14th Amendment grounds solve VAWA details with equal protection claims. That's Shargel in 97. Because the VAWA civil rights remedy is written in the denials of equal protection means the standards established by the civil rights case, although the VAWA remedy reacts to wrongful acts of individual legislative history, demonstrates the grading of remedy for those wrongful acts particularly, and those that do not effectively protect victims of gender motivated violence. VAWA civil rights remedy effectively remedies the problem of equal protection at state level by simply offering an alternative legal bias out from the victims of gender motivated violence. First plaintiff during a suit in the federal court do not have to contend the unjust output of laws of marital rape exemption and fresh complaint rule, which still exists in a number of states. Second, there is more evidence of female victims of violence receive fair treatment. Federal court, the VAWA civil rights remedy offers a federal form for victims of gender violence, along with the fact that remedy so specifically addresses the frequent harmful acts of violence against women, leading to the inevitable conclusion that the VAWA remedy is appropriate legislation to further claims to Section 1 of the 14th Amendment. Next off. 1. Overruling Morrison on the grounds of the Commerce Clause reduces humanity to mere commercial exchange that reifies the subordination of women under capitalism and prevents solvency. That's Resnick 2001. Case of upheld the Commerce Clause regulation, the interstate activity, and the economic clause, the interplay between the markets and the hopes of wars. They use the contemporary feminist agenda, the lack of market, working without household violence against women, do not include the activities economic in nature, and painfully ironically, women can be seen as also economic in nature, as a species of nature, is painfully ironic, a bundle of good and services. The Supreme Court many times acknowledged that women may be treated as commodities, the commentators seeking to engender more national rights making than other language in commerce, arguing that the Duluth commitments to freedom and status of information is the strategic reason why VAWA would apply to the Commerce Clause, that is by framing the problem of violence against women is embedded in the Commerce provides a deceptive accuracy and normative instruction on the degree of the economy's form by altered allocation of work subordinate to women. Obtaining equality for women depends on the grading recognition of commercial actors. Wolf explains in 1928 when the value of the right to vote is the receipt to regular income, the money I own seemed infinitely more important. And the unnuanced portrayal of victimhood by VAWA and the 1AC only reifies violence by recreating stereotypic binaries. That's Picker in 2003. The VAWA civil rights remedy, still mindful of popular and mainstream legal construction of victim and the agency remedy in the manner in which the rhetorically invoked in the binary economy, the woman is spectrum, woman is agent, and the private person public in which they address the complexity of women's life, this implication of tangible effects on women's life, it suffers from the structural flaws and promotes stereotypic depiction of victim that will fail to get at the nuance of what being a victim entails. And this reliance privileges hegemonic views of gender that destroy true reform and lead to backlash. The exclusive focus on state solutions unleash conservative forces that crush social change. That's Cooper in 2002. An exclusive reliance on the victim to make the claim that the rights of women's empowerment because the great essentialism is hegemonically represent the problems that privilege women, the generalization of the problems that concerns the women are marginalized, the subject accommodate the multi-layered experience, the focus on the victim subject, reinforce the depiction of life of women, life of women in the third world, perpetually marginalized by underprivileged women experience, the focus on the violence of the media that the response from the states have little to do with promoting women's rights, that the victims have the position to invite protectionist and even conservative response to the state, but this is one example, and of all protection women against from traveling outside the country, permission of husband, all male guardian, anti-trafficking agency. Agent of the VAWA campaigns that are contingent on the victim subject maintaining the feminist back of protectionist and conservative discourse. The exclusive focus on finding resolution though through appeals to state fails to consider the relevance of women's agenda in the new players as public spheres the power of sovereign states. And characterizing the other as a victim by reducing the other to a subject of stark suffering. As soon as the other begins to assert autonomy, the fantasy of victimhood disintegrates and it becomes a threat to the logic of capitalism justifying extermination. Zizek 2000. Purely humanitarian legitimization through deapologize the military and the catastrophe, the problem of the militaristic inhumanism, the way the militaristic intervention is perceived by the victims of hatred and violence. This is the subject. This logic of victimization is subject to be protected by the identified, the outside, the powers of the victims. Here we have it, not the ideological construction of the ideal victims. The NATO intervenes, not a political subject of the clear agenda, but a subject of suffering. The NATO strategy is thus responsible for the calamity against the government in here and the family, and the finally they come to prove their devotion to the family by bravely seeing that saving the children of the region flame. What we consider the paradox of victimization, the other remains the victim. The moment is no longer gives the victim to strike back, and so magical justice is fundamental. The crucial point of this is to recognize clearly the identification of the human subject as something that can be heard and made of ideology. But today's global capitalism idea of victimization is the very mode in which the real love of the capital exerts its rule. And the implication is capitalism commodifies the relationship between people, making genocide, nuclear war inevitable. The outcome of such a process can be seen in the bureaucratic administration of the final solution, Internationalist Perspective 2000. It's basically the relation between the people takes on the character of the thing, the acquired to the fundamental objectivity, and the fundamental nature of the relation between people when human beings and administering treating as things, thereby clearing the way for the removal, elimination, genocide. The outcome of such a process can be seen as bureaucratic administration, the final solution, and the organization of genocide. The responsibility of death killers like Adolf Eichmann, who can mercilessly administer a system of mass murder while displaying no particular hatred for the victims, no ideological passion for the project, no when the season went to get to the gas chambers where human beings are not the death killers, the quintessential bureaucrat functioning to the imperatives of the death world. As a human type, the death killer is the embodiment of the triumph of the instrumental reason to become a vital part of the state application of capitalism, the legacy and capital reification, and the identity period of the dress color, given joy by Martin Heidegger's conception of the Gestalt framing, in which it entirely reveals all beings, including humans, will be treated as epicent, stating a reserve in the raw materials manipulated will the reduction of humans, the raw materials they anti-chamber in a world when they can become so waste products discarded and turned away into chambers of Auschwitz and Ground Zero in Hiroshima. And the counterplan is the way out. Vawa can and should be divorced from capitalism, and symbolic value of equality solves case harms. That's Amar in 2000. Get in support of what consider the violence against women is mainly an interstate one deepest concern the GDP about the state lines. Indeed, the main goal is to ensure that women's access to the core organization of the victim herself can have the civil proceeding with the clear the proceeding the next of the federal one. The violence is logically symbolic, not important, and constitutionally by simple idea of equal natural civil regardless of the person as a condition with the vow was as symbolically refers to all whether the research no violence is merely random. Private assaults can be part of a historically rooted system of insult and degradation of all labels the system as an insult of civil rights abuse and equality issue. And this solves the critique. The first step toward an alternative future post-capitalism is recognizing that such a world can exist. Refusing to endorse capitalist justification is the only way to generate meaningful alternative. That's Mazaros in 2095. Too many people present the state of affairs and the fundamentally unalterable, the impression of favorable unalterability made the political reform there reason no alteration much issue to present itself in the finality of the predicament that they should devise the necessary to challenge it, the refuse to notice the blatant contradiction between the traditional self-justification of politics as the socially beneficial area of the sphere of the black idea and nature from the stage of development, the global capital system, and the setting phase of development commodities as a whole range of meaningful alternatives can be contemplated and successfully implemented. Finally, the critique's analysis allows for the subject to navigate the continuum of agency and victimhood and produce real change. The representations of the 1AC render that this impossible and the perm would never solve. That's Pickert in 2003. McKinney to work its feminist legal theory that women indulge in the rhetoric of imagery and violence and replace the reconstruction of sex and gender inevitabilities. Women are never fully victims of final age and then room for account of that and capture traditionally described that the Cheska row of agency and disempowerment. The women live in the days and either the total place and language, the intersectional categories of race and class, women to occupy the practice differential spheres of agency and victimhood. These difficulties, not the impossibilities of female leadership, may perhaps engage by focusing on a complex intersection of gender, race, and other factors. When violence may navigate the continuum of agency and victimhood, the better to empower themselves, perhaps as well a more educated audience that can understand the hesitation and ambivalence of such experiences even could gradually emerge. Case. One, states give women protections that VAWA doesn't. It's impossible to obtain damage. That's Levy in 2001. The Violence Against Women Act is congressional and underscored the defendants of would-be difficult women today sue their attackers of violent states after Bruce gender race scam against and the protection against all states broader than the civil rights version of the Violence Against Women Act. The uniform laws, I think the argument of the federal system is not with domestic violence. And no solvency, no plaintiffs will use them, and there are no court resources. That's Regan in 99. The attorney delaying the judgment, the light unlikely of enforcing the judgment will be nearly all abuse women. The case of the CR is referred to the millions of abuse women consumed without further delay in the court. The possibility of 646 district judges hearing 4 million additional cases, over 6,000 per judge is ignored by the CRR. And the CRR would overload and shut down the federal docket. That's Regan in 99. It is only the state courts that the women have great numbers being backed like CR rates the number of people and the relief in these provisions, even the 10 abuse of the CR claim would be 600 separate cases. That would work out 421 violence per judge. The 10% would be 60%. The federal court docket would never come to pass. All this comes to the federal and judicial system to remove this type of federal docket is an impending crisis.
Status of the counterplan?
Unconditional. Yeah,
it's unconditional. All right, let's talk about your links then. You have, first link is to the Commerce Clause, right? Your Resnick 2001 evidence.
Yes.
And then you have a different link from Pickart in 2003. You say VAWA promotes an image of victimhood when it comes to women, right? Recreating stereotypical binaries. And then you read a Zizek card saying that victimization would necessarily be the logic of capitalism. So why exactly wouldn't this link to your counterplan if you claim to enact civil remedies?
Because the counterplan doesn't endorse the commerce clause or the
But
economic.
if victimhood leads to
The
capitalism,
bottom of the K is the Picard evidence that's.
I read that Picard evidence, but
Right,
my question
it
is,
says that a critical analysis.
so victimhood is a link or is not a link? Is it or is it not?
An uncritical notion of victimhood is a link. Right?
Wait, so
Our
how do you
argument-
pass VAWA in a way that would not have victimhood? Because this first card, your first Picard card, does not mention one word about the economy. The reasons it gives for victimhood is because it still mimes popular and mainstream legal constructions of what a victim is.
Right.
And you
And-
reject that
and-
card saying that characterization.
And then the second Picard card says the way out of that is a critical analysis of it. Which we
Okay,
argue
let's talk about this
critique
second Picard card.
The argument is that on a discursive level, we break that down.
What do you mean on
We
a
are-
discursive level? Do you advocate then actually instating the civil rights remedy, or do you what are you doing to adjust it within your discourse?
Argument is going to be there is no difference between discourse and policy. The idea that there are two separate worlds is
I'm not asking about two separate worlds, but how does your discourse interact with the policy that you advocate? Why would saying something like
Yeah.
identifying that capitalism exists change the function of the VAWA civil rights remedy? Because your Picard card, it's definitely not about discourse. It's about how people perceive the remedy itself.
No,
No, I'm talking about your link. Still your link. Your link card says it's based on perception of society, right? That society mimes what we see in the courts, and if we have victimization happening in the courts, that would be mimed by
and our
society as well.
discourse can solve.
How?
That's the
Explain.
second- that's the second
Well,
part.
explain to me in your own words how it exactly
Sure,
solved.
but she uses a fancy word called chiaroscuro or something.
Mhm.
It basically means shades of gray.
Uh-huh.
And the ability, when you do a critical analysis, i.e. you talk about the way.
You're talking about this card, right?
victimization-
Or you're not talking about Amar, you're talking about Picard?
Yeah,
This
I think
is the last
it's the very last
Picard
card
card.
in the critique.
Very last card. There we go.
Yeah.
Yep.
Right, when you analyze the shades of gray that exist between the pure victim and the pure agent, you're able to avoid the trap that.
And how do we do this exactly? How do we,
A critical analysis is what she.
And why isn't VAWA itself a critical analysis?
How does the counterpoint provide a critical analysis?
Yeah, I'm just not sure how
The
the
discourse of E1 and C provides.
So it's your